Hello, everyone, and welcome to Everything That Doctors Want to Know About Reproductive Rights Litigation but Are Too Afraid to Ask. I'm Carmel Shachar, the Executive Director of the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School. A few housekeeping notes before we start. So this is a conversation between a physician and a noted legal scholar who really understands the context of this litigation. We strongly encourage you to submit your questions so that they can be incorporated into this discussion. We really want to hear from you. You can submit questions at any time by using the Q&A feature found in the meeting controls at the bottom of your screen. I see somebody has already used that to ask if closed captioning is available. We will be recording and captioning the event, but I believe that we can try to put closed captioning on live. It just won't be done by a human being, so it might be a little bit funky. So I see closed captioning has been enabled. Thank you, Laura. So please submit questions at any time using the Q&A feature found in the meeting controls at the bottom of your screen. You can also join the conversation or submit questions on Twitter at Petrie-Flom using the hashtag SCOTUSRepro. Again, that's hashtag SCOTUSRepro. If you have any technical issues, the best way to get a hold of us is to email petrie-flom at law.harvard.edu, and we will try our best to sort things out and help you. If you are interested in the kind of events that we put on, and we really hope you are, we have a really robust event slate. In fact, tomorrow we have an event looking at the use of psychedelics to address trauma. Then we strongly encourage you to sign up for our newsletter, which goes out only twice a month, so it won't clog your inbox. To read our blog, The Bill of Health, which often hosts digital symposia on similar topics, and to check out our upcoming events on our website. With that, I want to introduce the two people who will be discussing the topic at hand today. We have Louise Perkins King, Assistant Professor of Obstetrics, Gynecology, and Reproductive Biology at Harvard Medical School and Surgeon, Division of Minimally Invasive Gynecologic Surgery at Brigham and Women's Hospital, as well as Mary Ziegler, the Stearns Weaver Miller Professor at Florida State University College of Law. I'm going to turn it over to these two very capable scholars and physicians to launch us into the conversation of what physicians should know about reproductive rights litigation in the current climate.
Thanks so much for the kind introduction. I'm so happy to be here, and I'm so grateful to Mary Ziegler for attending and sharing her expertise with us. In anticipation of our conversation, I've spoken with a number of other physicians who are concerned about the status of abortion care and what changes we can expect and how we can ensure that we can conscientiously provide care to our patients moving forward. So I'd love to start our conversation by asking, how did we get here? We were all under the misapprehension that we had an established right to provide this care or right to this care. And we know that that is in serious doubt. And I know this is a complex question to answer. I recognize that, but understanding the history and some of the progression of the law over the past, 50 years, can be helpful to people if you could summarize it a bit for us.
Sure. I mean, and so my apologies. I'm recovering from a bug, so if I cough or lose my voice, my apologies. So I think they're kind of the legal how we got here, which is to say that we're not really talking about Roe v. Wade being overturned. We're talking about a case called Planned Parenthood versus Casey, which was decided in 1992 and already kind of weakened abortion rights, including the rights to involving provision of abortion care, and said that states could regulate abortion so long as their laws weren't unduly burdensome. And that created something of a patchwork, right? So depending on where you provide care, the rules that govern you are already going to be very different depending on your zip code. And Casey opened the door to that. But I think a lot of what got us here isn't doctrinal. So you can organize it into sort of what did progressives inside the medical community and outside the medical community do wrong, and what did conservatives inside and outside the medical community do right. So I'll talk about both of those things. I think for progressives, there's been a sense in which I think questions about reproductive health care have been left largely to politics and to lobbyists and to lawyers. So there hasn't been as central a role played by healthcare providers, especially until I would say the past 5 years or so. And that's a historical discontinuity. If you go far enough back, the original impetus for criminalizing abortion in the 19th century came from healthcare providers. The initial push to reform criminal abortion laws in the 60s came from abortion providers or healthcare providers writ large. And so it's been kind of unusual the degree to which healthcare providers haven't been at the center of the conversation. That isn't to say they haven't been involved, right? So ACOG routinely would submit amicus briefs in the Supreme Court, would testify before Congress and so on. But the American Medical Association, by contrast, didn't do that much of that. And healthcare providers in general, I think, were not as involved, especially those that didn't perform or provide abortion care, but may have had an opinion about it. But even those who did, I think, provide abortion care. Why that is complicated, partly to do, I think, with the threat of violence against healthcare providers who perform abortions, partly to do with the local politics of abortion in different communities. But that's something that I think is significant. There's also been what one abortion provider, I think, nicely put it as sort of leaving crumbs. If you leave crumbs at a picnic, an ant will find them. And I think there have been lots of crumbs left by progressives in politics when it comes to abortion. So in particular, there's been a reluctance to talk about what abortion care actually is, like what an abortion is, what abortion doctors do. There's been a reluctance to deal with the fact that there are obvious racial disparities in terms of who receives care in the United States. There have been for decades, and those disparities, I think, have only become more pronounced since 2004. There have been, silences around the fact that abortion is stigmatized, or that abortion care is often, physically removed from other care performed in freestanding clinics that don't, and less so in other kind of medical facilities. And I think there's been, all of that has made it easier for anti-abortion groups to introduce restrictions that were very effective, and particularly effective in limiting access for people who were the least influential in the pro-choice movement and the most likely to actually be seeking abortion and the most likely to be affected by bans on abortion, which was predominantly low-income people, people in rural areas with low penetration of care to begin with, people of color. And so all of that, I think, has made it easier for conservatives to make the progress they have had on abortion, and kind of relatedly made it easier because there's been both sort of an over-reliance on reproductive rights litigation and a disconnect from the courts. So it's quite stunning when you read the history, but progressives have been very bad at mobilizing voters around the courts and very reliant on litigating in the courts to protect healthcare workers and patients seeking reproductive care. And I think that dichotomy is part of what got us here. On to the second point, what did conservatives do right? Conservatives were very successful in reframing control of the Supreme Court as an issue that ordinary people ought to care about. This was not something that had been very effectively done before. Even though presidents going all the way back to Richard Nixon, even earlier, tried, it hadn't really been successful until there had been this campaign around Roe. So if you look in 2020, for example, there are polls suggesting that Supreme Court justices were one of the most important issues for voters, behind only, the economy and COVID, which is quite striking. You would never have seen a poll like that in earlier years. There was also, I think, a kind of successful incremental chipping away at Roe that weakened it. So the kind of patchwork I described after Casey was not an accident. It was the result of a plan to water down abortion rights so substantially that they would seem incoherent, and that when the time came to ask the court to reverse Roe, the justices would see that it would be no big deal to do so because abortion rights in a real sense were already gone. And finally, I think that part of how we got here is just that the Supreme Court doesn't operate the way it used to in US politics. There have been conversations for decades about the court caring about its legitimacy, both in the legal community and in the broader political community, and that would discourage the court from doing things that would be unpopular, like taking away abortion rights for healthcare providers and patients. And that isn't true anymore. So the types of people who are nominated to the court, the types of sort of communities that they care about, whether that's politically or legally, all of that has changed in fundamental ways that I think even people who study this were surprised by. So there's sort of two streams of how we got here, involving what people who support reproductive rights could have done better and what people who don't support reproductive rights were doing rather well.
Yeah, the themes that I hear you speaking about resonate deeply with me, especially in terms of the silence. There have been a couple of articles in the lay press about the silence of individual physicians, healthcare providers, and as well the systems within which they work about providing care and the importance of providing care and the normalizing to some degree this essential piece of medical care for people so they understood how prevalent it is and how important it is. I'm also wondering, when I read the history and the jurisprudence, I was struck, and I remember being struck at the time that it was decided, by the case Gonzalez versus Carhart, and this concept of scientific uncertainty and this underlying premise that there's almost a distrust of healthcare providers to know what is right. And I wonder how much that is playing into it. I know there's very little discussion of the public health reasons behind abortion care in the oral arguments or in the briefs. So if you could comment on that briefly, more to our silence and how we need to become more involved as healthcare.
Yeah, that's definitely been a big piece of it. So for decades, until pretty recently, a lot of the abortion debate wasn't about whether you have a right to abortion or whether there's a right to life. It was about what abortion actually is. And so increasingly you saw anti-abortion groups arguing that you couldn't trust individual doctors and you couldn't trust medical organizations, and you particularly couldn't trust sort of elite medical organizations, right? So sort of like the AMA or Harvard Medical School. These were the sort of groups that in their view or ACOG, right, that had been, they would argue, kind of taken over by pro-choice people that would put their pro-choice principles before the evidence, right? So that meant that people who are opposed to abortion were looking for conclusions about scientific or medical questions from, you know, either doctors who were not part of those traditional institutions, or from people who weren't specialists or even people who were doctors at all. And so the idea of scientific uncertainty, Gonzalez, that Louise mentions, upheld the so-called Federal Partial Abortion Ban Act, and the court in the case said that when there's scientific uncertainty, legislators should have more room to operate. That was significant because it sort of legitimized the idea that it's not very hard to generate scientific uncertainty, even when there's a pretty entrenched consensus in the medical community. If some people disagree, that's enough to generate uncertainty. And it also it sort of created a cycle of trying to produce uncertainty, right? Because if you could convince the court that there was uncertainty, that meant you could restrict abortion more. So then it created a cycle whereby state legislators would make more claims, some of them outlandish, and then the courts would say, well, you know, some experts say that this is true, so there's scientific uncertainty. So this kind of both reflected and furthered, I think, a growing distrust of the medical profession. And it's striking because, as Louise said, there's a case before the Supreme Court now, as many of you know, that seems likely to result in the reversal of Roe. And at the time Roe was argued, and even when Planned Parenthood versus Casey was argued, there was a focus on what would happen from a public health standpoint if states criminalized abortion. And we see this happening in real time in Texas. And that was almost entirely absent from the court's discussion, in part because I think there has been a sense in which anti-abortion groups have successfully convinced the court and segments of the public that even if there are public health questions about abortion, that medical providers are not particularly well positioned to answer them. And medical providers have themselves sort of been absent from some of these conversations in a way that makes those arguments all the more effective.
There's a lot of questions in the chat. And of course, I've had many of these questions sent on to me to share with you. And recognizing that you don't have a crystal ball, people want to know what is going to happen with this decision and how will it change abortion access moving forward. I think you've alluded to the fact that abortion access in many parts of the country is already deeply restricted. To some degree, it's already a done deal. But what do you anticipate will be the result in Dobbs, and how might it change the landscape in your opinion?
Yeah, I mean, I think so. I'm expecting the court to say that there is no more right to choose abortion in Dobbs. I could be wrong about that. And if the court doesn't say that in Dobbs, I would expect them to say that in a year or two. I don't think there's really a scenario where we don't get to that point. So the less extreme possibility in Dobbs is the court says viability, right? That's the point at which states can ban abortion, that doesn't make sense. And that'll open the door to bans earlier in pregnancy. And it'll probably fuel this fire of state laws testing the boundaries. If the court does overrule Roe, there are somewhere between 20 and 25 states that already have laws in place that would effectively ban abortion. Some of those are a little more murky because they're pre-Roe bans that the states have retained. Some of them are a little clearer because the states have more recently passed a trigger law or a constitutional amendment or some other measure that would automatically go into effect when Roe is gone. There are obviously progressive states that would not ban abortion and would likely expand access to abortion. And then there are states, I think, like Florida, that are a little bit politically ambiguous, where they may eventually, because they have Republican majorities, go all the way to banning all abortions, or they may decide instead to ban some but not all abortions. And I think that's politically going to depend on what kind of reaction there is to the Dobbs decision. And that's going to be true, both the reaction among healthcare workers and also the reaction among the electorate writ large. So exactly what the landscape looks like isn't going to be clear. In the states where abortion is banned, you'd expect to see it banned, from all abortions banned, with maybe exceptions for life of the pregnant person. Some states may have rape and incest exceptions. Some states may have, health of the pregnant person exceptions. Some states will have medical emergency exceptions, but a lot of those are going to be probably narrow and kind of ambiguously drawn. So you would expect to see even not many healthcare providers taking advantage of those exceptions, in part because the criminal consequences and other consequences, whether those are licensing consequences that states have put in place, are pretty severe, right? So a lot of healthcare providers in those states are not going to likely want to run the risk that they'll lose their licenses or go to prison for, we're talking like extended periods of time, like up to 99 years, for example, in Alabama. So you would expect to see large parts of the country with no legal abortion, and some large parts of the country with legal abortion, and then states that are sort of battlegrounds where the exact contours of care are going to be contested.
And to put that into context, of course, as things are ambiguous and you're facing these penalties, true surgical emergencies can present in the setting of pregnancy, separate and apart from elective abortion. Ectopic pregnancies or pregnancies that are spontaneously ending but causing severe bleeding. And at least anecdotally, we're already getting significant reports of women experiencing severe morbidity related to delays in care, given the concerns that physicians have for whether they can legally act or not. Which is, of course, the underlying story of a patient who passed away in Ireland and led to all of the changes that they saw there. So certainly, statistically, we're seeing already the effects of this in Texas and some other states. With all of that in mind, so many of us are trying to understand how we can provide care. Obviously, in a state like Massachusetts, we have the Roe Act. We feel very confident providing care within our state's borders. But with the advent of telehealth, many of us have this desire to reach out and help in other states, especially for medical abortion, which is a predominant method of abortion ahead of, in the early trimesters and represents at least 70% of abortions performed. But my understanding would be, if I'm in the state of Massachusetts, I can't provide telehealth to a patient in Texas unless licensed there. And then I would be at least subject to losing my license in Texas if I performed an act that contravened their law. But similarly, I might even be open to some liability. Can you expand upon what we'll be facing as we try to provide care in states affected by these restrictive laws?
Yeah, I mean, I think that some of you may have heard California had floated a proposal to make California like a sanctuary state for people seeking abortion. And you may wonder, given the availability of medication abortion, like, why are they doing that? And it's for the reasons that Louise is describing, because from a liability standpoint, it's much more straightforward to pay to help patients come to a place where care is legal than it is for a physician to be doing telehealth abortion, because it would be quite likely that the physician would lose their license in the state. In practical terms, is that physician going to face, imprisonment in Texas? Like, probably not, because Massachusetts is not going to extradite someone for doing something that's legal in Massachusetts. It would mean, if you're a physician, you couldn't go to Texas, right? So if there was a conference in Texas or a wedding in Texas or something, you would be more or less precluded from doing that. But there are other tricky questions for physicians, because many of them will instead face scenarios where, a patient comes from. So at the moment, it's worth saying, at the moment, states are saying, we're not going to punish the pregnant person, we're just going to punish the healthcare provider. And some states have alluded to the idea that they're going to punish others too, like they're going to punish the person who helps to pay for the abortion, whether that's an abortion fund or like a parent or whatever. But at the moment, they're saying, we're not going to punish the patient. I wouldn't expect that to last, for the obvious reason that it's going to be virtually impossible to enforce these laws by punishing healthcare providers from out of state, which is going to mean that states are going to want to enforce these laws somehow. And the logical way to do that is going to eventually be to punish patients. And that's already happening in some places, right? There are states that sometimes punish people for having self-managed abortions. There are states that punish people for conduct during pregnancy, using child abuse or child endangerment laws. So if you face a scenario where you're worried that a patient will be punished, that's, I think, more going to be an ethical dilemma for healthcare providers, because if states like Massachusetts do try to make it easier for people to come from out of state to get abortions, it would be much more complicated, but also much more likely that that state could punish that patient when they return to the home state, because that patient lives there, right? So and there are a lot of very messy questions in this area called choice of law about who will decide what happens in that kind of scenario. Some of those cases date all the way back to the slavery years, when there were conflicts about what happened to people traveling from slave states to free states. There are other cases that are more recent, but we don't know the answer to that, right? We don't know if states are going to punish patients, and if they do, we don't know whether they'll be able to if the patient is traveling to a place like Massachusetts that views their conduct as legal.
Yeah, and the fact that we don't have clear jurisprudence except those dating back to that era is at the very least interesting. I'm curious, someone has asked it in the chat, but you'd mentioned contributing to funds to allow for patients to travel to states that do provide care. And there is concern as well, and I don't want to squash anybody's desire to contribute to these funds. I contribute to them, but is there a theory under which simply contributing to those funds under the Texas law would open you to liability?
Yeah, absolutely. So, I mean, I don't know in a post-Roe world the extent to which we're going to have laws like SB 8. I mean, SB 8 is very much a law designed for a world where Roe still exists. So states like Texas are going to go for direct criminalization, right? So they may also directly criminalize people donating to funds. I mean, that wouldn't surprise me at all, because the language of SB 8, I'm sure those of you who have read it, is aid or abet. Aid or abet is not something we say in civil tort cases, right? It's criminal law language. Yeah. And that's because they're anticipating criminally punishing people for doing the same thing. So you would expose yourself to liability, either to whether civil liability or criminal liability. Again, if you don't cross Texas state lines, nothing is probably going to happen to you. So in reality, that's not likely. I mean, again, it would mean, you probably are not going to want to go to Texas if you're doing something, if people have filed a lawsuit against you, or there's an arrest warrant pending. Of course, the other variable, and this is, I think, something that people will also have to think about if you're a healthcare provider, is, the probability that you'll get caught, right? I mean, in many of these instances, you're going to have people traveling from out of state and taking a pill in ways that are not going to be particularly detectable. And that's true of donating to abortion funds too. So I think there are real legal risks. They're probably considerably less in the way of practical risks, given the probability of anybody actually being able to do anything to you.
Yeah, it's interesting. There was a large conference for the surgical discipline that I'm a part of not too long ago in Texas, and I specifically didn't go just in case I wanted to, I don't know, who knows what, but I just was like, you know what, I'm not even going to go to Texas just in case. So, it just gets difficult to think about these things. There's some wonderful questions in the chat. I have one final question of my own, and I'll hold it to the end. One of them is a genetic counselor who's asking us about limitations that states could put on our ability to counsel patients. To what degree can states limit what we say or demand that we say to patients? And I mean, one excellent example, again in Texas, is the right to know legislation that requires that physicians read from a pamphlet that has a lot of misinformation in it. So I always found that interesting. And when I was in my residency in Texas, I specifically refused to read from it. And as you say, it's very hard to enforce that against me. How could you even prove what I did or didn't read? But what do you think about this concern that there would be legislation that would actually bar physicians from even mentioning abortion in some states or counseling patients about abortion, especially in the context of genetic counseling when we're detecting anomalies that could be lethal anomalies or could put the mother's health at risk? For example, anomalies that lead to fetal hydrops that then results in an incredibly distended head and requires interventions for the mother's health. Any thoughts in that regard?
Yeah, I mean, we're quite likely to see that. So as Louise suggested, even now in a world where Roe is the law, the court has been sympathetic in some ways to so-called informed consent laws, which usually require you to, read or provide patients with certain scripted information. The exact contours of this have never been that clear because the Supreme Court hasn't decided that many cases. The court has generally said the information needs to be truthful and not misleading, but that hasn't stopped states from kind of pushing the boundaries and testing, information that's, not proven or that's disputed or that's, not supported by any research, et cetera. And courts haven't done a lot to really stop that even now. So it's hard to imagine that if the Supreme Court says there's no right to abortion, that the court would then say, the only potential, I think, would be if physicians say they're trying to invoke the First Amendment, but the court has been unsympathetic to that claim too, because the court has often said that when physicians are performing informed consent, they're practicing medicine and that the speech is only incidental to conduct and that there's more regulatory power that we give the state, the First Amendment notwithstanding, when speech is incidental to conduct. So I think, again, this is an area where, and I would also be particularly worried about genetic counseling because there's, I think, within the anti-abortion movement, a lot of anxiety around genetic counseling generally. So it wouldn't surprise me to see legislation, prohibiting genetic counseling full stop, right? Not just regulating it. And there would be less, preventing that in a world where the court thinks there's no right to abortion at all.
Mm-hmm. And the First Amendment claim hasn't been fully tested. Is that true? I mean, in the context of demanding that we say things that are patently incorrect. Science.
Exactly. Yeah. So, I mean, the court has upheld informed consent laws, but the one that the court upheld was, much more anodyne, right? It was sort of information about gestational development and like the availability of child support and things that may not have been particularly relevant to patients, but also weren't actually false. So it hasn't been tested. I think I'm just skeptical about this court's reception of it if the court thinks that the state has broad authority to prohibit all abortions. But yeah, I think there's somewhat of a chance because it hasn't been fully litigated and the court does seem potentially more interested in the First Amendment than in the idea that there's a right to choose abortion.
One of the questions in the chat, and I'm just going in order, it dovetails with the question I was saving that is my own question, which is, how can we be helpful? How can we change this script moving forward? You started some of our discussion with what those of us who would like to see a right to abortion preserved, and one preserved nationally, have failed to do. We talked about our silence and how we relied on the courts too much to sort of defend our rights, but didn't politically act to really engender and nurture political support for a right to abortion. Correct me if I got that wrong. But what else can we do as healthcare professionals moving forward to get on the right path, to try to, we can't reverse this tide, but to try to ensure that we at least preserve what we do have in the states that we have, and create changes that would be beneficial to our populace as a whole?
Yeah, I mean, I think there are kind of two categories of things that could be done, and sometimes they're in some tension with one another, right? So there's a sort of political pressure point, right, where it's true that healthcare providers haven't been front and center in conversations about the importance of abortion rights. And it's also true historically that when healthcare providers have intervened in those conversations, people have listened, because healthcare providers are in a better position to know what abortion actually involves than most other people. So I think one thing that healthcare providers can do is to actually, become politically involved, particularly at the state level, but I think at the national level too, because I think that the exact contours of what comes next will depend in part on whether there's a political reaction to what the Supreme Court does, and the extent to which politicians and other stakeholders feel that something bad will happen to them if they ban abortion, right? And so I think being politically engaged, and politically engaged in this context, I mean, in ways that are public, right? So not just donating money, but, kind of putting your name on it, if you will. The second way, and I think there's some tension here, is doing things that are more under the radar to actually ensure access, because probably the kinds of political change we're talking about is definitely, or legal change as well, right? If we're thinking about kind of recreating some kind of constitutional foundation for abortion rights, those are things that are probably going to take a while. And so there's also a way in which healthcare providers in the meantime can, in their own practices or in local medical organizations, try to facilitate access both for people in state and people from out of state. But that often could kind of undercut political pressure, right? Because the more people can access this care anyway, regardless of what the law says, the less concerned they're going to be about the fact that it isn't officially protected. So I think there's somewhat of a dilemma, I think, for people who want to get involved in this about exactly what balance to strike between those two interests. But I think either of them would be helpful. And I think, recognizing that there could be some, probably if you're in a place like Massachusetts, it'd be relatively moderate, but some risk to you in doing this, right? And being more politically open, or in trying to help patients from out of state. Those are things that may carry some moderate risk for you. Obviously not much, right, compared to what people would be facing in other parts of the country. Yeah. But I think a willingness to realize that is probably important too.
And that's the tension too, because so many times I have conversations with people who provide care about being more vocal, or to systems and leaders in systems about being more vocal about the care that they make available and provide and are proud to provide. And they want to be vocal and want to make sure that the populace understands that this is essential healthcare that is provided. And yet at the same time, they don't want to limit the ability to provide that care by being too vocal and attracting too much attention, and making things difficult for the patients who are coming through the doors. It's a really hard needle to thread. So I haven't figured out the right balance there, but it's important for us to continue talking about it. There's an interesting question here, sort of notably specific to being here in Boston right now. In the Northeast, we have the most universities per capita. And someone says, if I'm from Texas and I come to go to school in Massachusetts, and then I obtain an abortion while I'm in Massachusetts, would there be any trouble when I return to Texas? And of course, I think you've answered this to some degree, but not, it's worth talking about again.
Yeah, I mean, the answer is that we don't know, and it depends, right? So, At the moment, there wouldn't be, because states have so far been saying they don't want to criminalize the patient. I, for one, am not confident that that's going to continue. So I would not be confident, that that's something we can rely on going forward. If a state said, I want to criminalize the patient, then the question would be, can they do that? And the answer is that it's unclear, and it turns on choice of law principles. So there's basically sort of two schools of thought on this. One would be that if your conduct is legal where it took place, right? So if the abortion was legal in Massachusetts, Texas shouldn't be able to say to you as a student coming back to Texas, Massachusetts had no right to do that. Because among other things, there's a constitutional right to travel. There's, federalism principles. On the other hand, some modern choice of law cases say that states get to decide the rules for people who are domiciled, right, who live in those states. And that's been true in some criminal law context recently, where states have said, if we say you can't, use this drug and you travel out of state to use the drug, we don't want to incentivize people to get around criminal laws by traveling. And so it's not clear. I mean, if I were guessing, I would guess that you could be punished if you get back to Texas. Again, the more interesting question would be like, there are lots of layers of uncertainty that may make that less concerning to you. There's the probability that anyone would know. There's the probability that Texas's law, that anyone would prosecute you, which may depend in large part on your identity, whether that's your class identity or your racial identity. And then the probability that a court would say Texas's law applies. So all of that may result in you thinking that you're not overly concerned, but there's certainly a possibility. And there's a lot of legal ambiguity because courts haven't really had to flesh out these questions about choice of law in a meaningful way in a long time. So we won't really know until we know.
Yeah. And of course, someone would have to know that this even occurred. There's a mention in the chat of protecting the identity and home states of abortion patients. And of course, there would be no reason for us as healthcare providers to release that information. In fact, it should be protected under HIPAA. So certainly nobody is going to be keen to release that kind of information. So it'd have to be.
Exactly. Yeah. I mean, and it would have to be a scenario. This is really the logic of the Texas SB 8 bill, right? Is that you need to have a network of informants to get meaningful enforcement of these laws, because it's not going to be healthcare providers doing that. It's probably not, I mean, it's going to require either, family members or friends or you say something on social media or something. It's somebody who knows the person. So absent that kind of scenario, there isn't going to be a meaningful enforcement mechanism. It's more, if that were to happen, what would legally go down? And we don't know the answer to that either.
True. So building on, you mentioned a moment ago that the enforceability of these laws and the chances that states will come after people also depends to some degree on the person's identity, whether it be an identity related to their social standing or to their race, which I think is very true and has been borne out in so much of the criminal law cases surrounding pregnant persons, where we've seen Lynn Paltrow's work documenting the extensive criminalization of behaviors in pregnancy, and Professor Michelle Goodwin as well. So there's a question here about what can be done to prevent an increase in maternal mortality from abortion bans, especially for Black persons. And I think we've talked a little bit about it, but it'd be great to dig in a little bit deeper into this because it's so important. I mean, we've seen the maternal mortality rate increase in Texas, not even just with SB 8, but prior to that with more and more restrictive laws. And we've seen that maternal mortality rate increase more dramatically and more per capita for Black persons. So access to abortion is a piece of how we can address maternal mortality, in the sense that when a person does not wish to proceed with a pregnancy, especially if it's related to comorbidities that will make that pregnancy very dangerous, we should be able to listen to them. I wondered, beyond some of the things we've said so far, if there are any other thoughts you have in that regard.
I mean, other than just either at the national or state level doing other things to deal with maternal mortality, it's striking how little there has been on that, given that in theory there should be a bipartisan consensus that maternal mortality is undesirable. People who don't agree about abortion should agree that maternal mortality is undesirable. So I think that that's probably the most useful thing. I'm not optimistic about that because it's also likely to be true that the kind of racial disparities we're already seeing will be exacerbated because not only because of just access to care and other structural inequities that have led to higher maternal mortality rates for persons of color, it's also that people of color are much more likely to actually encounter the law enforcement and the justice system, and that's borne out by what happens abroad in places like Ecuador, where abortion is criminal. It's disproportionately people who, have less income, people who are indigenous, people who are, the descendants of slaves who are likely to be criminally punished for abortion. So that will likely lead to more of a maternal mortality gap going forward, because those are people who will not seek care when they are having complications in their pregnancies, or even if they're having a miscarriage or an ectopic pregnancy, because they're going to be afraid of what will happen to them if they go to the hospital. So I think in addition to what you can do vis-a-vis abortion, I think trying to do, especially as healthcare providers, making maternal mortality more of a political issue than it is now, or more of a priority than it is now, would be valuable, because it's something that gets a lot of lip service, but ultimately legislators don't tend to pay a lot of attention to.
Yeah, that's true and disheartening. But it's stated very succinctly and accurately, unfortunately. There aren't any more questions that I see at the moment, but I wanted to continue to circle back to our discussion of, how to get our knowledge as healthcare professionals out there in a way that is effective. I think that is, you just mentioned making sure that politicians are aware of the issues surrounding maternal mortality and are taking it very seriously and putting forth efforts that are meaningful. And we talked earlier about this question of scientific uncertainty. When I listened to the oral arguments for Dobbs, I was just struck by the way that the term viability was thrown around with no consideration of what that even means, how it's even important in reference to the actual timing of most elective abortions. There seems to be so little knowledge of the actualities of abortion care. So maybe in our remaining time, and if the audience has questions on these points, we could sort of brainstorm really concrete things. I feel that I haven't done enough. I mean, I've contributed to briefs from ACOG, including in Gonzalez, and tried to work on things that could be helpful in this regard, but obviously, I'm not conveying that information in a way that's meaningful to the people who can actually make decisions and make change. So, what do you think, aside from briefs, because those don't work? Banging on doors on the Hill. What else?
I mean, I think public writing, I think sort of op-ed writing in places that a lot of people read would help, because I think there's been an understandable reluctance to do that sort of thing among healthcare providers, because healthcare providers who have done that have sometimes faced, death threats, and more so, I think, than other people would have. And so I think there's a gap in public discourse about abortion. And it's really actually striking in the Gonzalez opinion, because the Gonzalez majority has this long description of what abortion is. And then the dissent is all sort of about rights and choice and equality. Like, there's no account of what abortion is, or about what abortion doctors do, or about why doctors who don't perform abortions think abortion is still care. There's nothing, it's just not there at all. And I think that's representative of something bigger in the discourse. And so I think the places I think that conversation needs to happen are more just in the paper, on TV, places where ordinary people can hear, because I think that anytime people who perform abortions, or people who are healthcare providers who understand the science of abortion, are silent, people assume that that's for a reason, right? They assume that there's something that people don't want to say, that they have something to hide, that they're reflecting some kind of discomfort with what they do. And so I think, again, I don't think that's something that would change anything necessarily immediately, but there's lots of evidence, for example, from Ireland, that what was a game changer in Ireland in legalizing abortion was not It wasn't international human rights law, although European countries have much stronger commitments to international human rights than we do. It wasn't domestic constitutional law. It was essentially people telling stories, right? It was healthcare providers telling stories about providing abortions, and it was people who had abortions telling stories about the abortions they had. And so I think, and in some ways, the reasons to do that are stronger than ever now, because Roe is going to get overturned anyway, right? It's not like if you say the wrong thing as a healthcare provider, that's going to doom abortion rights, because they're already doomed, right? So to some degree, I mean, you may personally experience negative consequences, and I don't mean to minimize those, but if you're someone in a place that's, you know, where you're not likely to experience that, then I think telling stories has proven in other places to be very powerful. And I think especially it's stories where you're not talking to the courts and you're not talking to politicians, you're talking to just ordinary people who we already have reason to believe are not going to be happy when Roe is overturned, and talking to them about why it is a bad idea in the ways they believe and what they, you know, why they should care and that sort of thing, in ways that I think people who are not trained medically are not going to understand unless someone is helping them understand.
Yeah. So getting out there, telling our stories, we can certainly work on that. Do you think it's worth, as physicians, and all healthcare providers that work in this space, we understand that the concept of viability is never a set point. There's never ever going to be a set point of viability. It's dependent upon multiple issues related to the condition of the fetus and the condition of the person gestating. So it's always very fluid, and that's why the Massachusetts Roe Act is so powerful, because it allows for fluidity within that space in a way that is meaningful and was informed by a lot of physicians who helped craft it. So I wonder, is it worth trying to explain the complexities of that to people so that they better understand, in these rare instances where we're up against the viability cut points, which is, you know, a very, very small proportion of abortion care, in those settings, how complex that care can be?
Yeah, I think so. I don't know to what extent we'll be talking about viability nationally, because I don't expect the Supreme Court to be focused on viability. I think they're likely to just say there's no abortion right at all. Okay. But I think it's important anyway, because of course, one of the ways that there's been this kind of incremental chipping away has been because there's long been discomfort in large swaths of the American public with abortions after a certain point in pregnancy. So if you look at polling on abortion, there's pretty large majorities that support access to legal abortion early in pregnancy, and it falls off really dramatically after the first trimester. And so I think it's helpful for physicians in those circumstances to explain that, because of course it's a slippery slope, right? Once you assume abortion is wrong under some circumstances, you could assume it's wrong under other circumstances. But I think the conversations you're imagining around viability are really important, in and of themselves, but also sort of as a model about how you'd want to talk about other issues earlier in pregnancy or other medical issues that come up in states that have banned abortion, like what it means to have a medical emergency, you know, even like what is an ectopic pregnancy. I mean, I think a lot of legislators don't understand that, and a lot of people don't understand that, right? So being willing to talk about that in a nuanced way, I think is helpful too. And I would also say it's probably helpful for medical providers to have their own voice. I think sometimes when healthcare providers have been vocal in the past, it's been sort of talking through the talking points that political pro-choice groups have given them. And there's a reason for that. But also something is lost when that happens, because there's distinct contributions that healthcare providers could make that sometimes they're not making, because it's perceived that doing so would jeopardize the legal strategy or would undermine the political strategy. But again, when Roe is gone, the legal strategy is not going to be the same anyway. So I think there's more room for thinking about how healthcare providers can say things that are distinctive that other people are not saying in political or legal spaces.
Yeah, and I think using your own voice is exceptionally important as well. Since we've been talking about one end of this question in terms of viability and what that might mean, there's a question in the chat. Any estimate on the likelihood that the Supreme Court declares fertilized eggs as persons? Essentially, they wrote residents in America, but I think they mean this question about personhood, and questions around abortion as murder and unconstitutional in any state. But again, centering on this concept of the embryo as a person, which of course would call into question IVF and go in a whole different direction. Wonder what you think about that.
Yeah, I mean, I don't expect that to happen quickly. It's certainly what the anti-abortion or right to life movement wants, right? It's not called the get rid of Roe v. Wade movement. It's called the right to life movement, because the movement has always been a movement around personhood. And that was true going back to the 60s. It's true now too. So there are already briefs asking the Supreme Court to do this. And if the Supreme Court reverses Roe, that will just intensify that effort further. I don't anticipate that that's going to work, at least if you're reading the breadcrumbs from the Supreme Court's oral argument in December. Brett Kavanaugh, who seems to be one of the key votes in the case, was essentially saying, in his words, the Constitution is neutral, by which he meant there's no right to life, there's no right to choose, there's just, the Constitution doesn't say anything about abortion. I don't think that all of the conservative Supreme Court justices agree with him. I mean, Clarence Thomas's opening question essentially was, we can criminally punish a pregnant person who takes crack cocaine, so why can't we punish people for abortion? That is like, if you know what people, if you've studied this, that's a personhood question. So personhood is a possibility down the line. So while I don't think it's anything healthcare providers have to worry about imminently, it's something they'd have to worry about eventually. And just to be clear about what it would mean, right? The 14th Amendment of the US Constitution, which talks about due process and equal protection, uses the word person. And anti-abortion groups have argued that that word, when the 14th Amendment was written, was intended to encompass people from before and after birth, beginning with, the fertilization of an egg. And they're quite comfortable with the other some of them anyway, with the implications that personhood would have outside of the abortion context, whether that's for, emergency contraceptives or infertility treatment or, other things too. Of course, the word person appears in areas of the law that don't even have anything to do with healthcare. But I think that's more, a kind of down the line proposition, and that people should be aware of, and if they're concerned about, should try to guard against, rather than something we're likely to see, in the next year or two.
I'm going to close us out by talking again about disparities, because there have been some interesting questions that I've caught in the chat. One noted that persons who are incarcerated obviously have no ability to access anything outside of the state in which they're incarcerated. And the disparities in access for persons who are incarcerated in terms of the care they receive, even if they desire to continue their pregnancies, is something worth highlighting momentarily. I think we can just say, yes, if you are incarcerated in a state in which abortion is illegal, of course, you won't be able to access that care. And it's unfortunate, but it's true. Similarly, persons with disabilities who have difficulty in traveling also won't be able to access care outside of the state in which they live, or certainly won't be able to do so as easily. And similarly, these questions all apply to and touch on the fact that you've already mentioned, which is these bans will have disproportionate effect on persons who don't have the ability to travel out of state, or simply don't have the knowledge. So in many of these states,
internet access.
Yeah, you don't have internet access and don't have sex ed. I mean, as any obstetrician can tell you, we've all delivered, helped persons deliver who were, the youngest for me was 11 years old, completely unaware of what pregnancy even meant. And so that's still possible in the United States because of such a lack of fundamental sex ed. So just highlighting those issues that have been raised by some of the persons in the chat. And finally, is there a role for medical schools to ensure that all future physicians are taught about women's health in its entirety? And so I'll build upon that comment. The physiology of women's health and pregnancy, or just the differences between a female and a male body, are generally given fairly short shrift in medical schools in general. And in many medical schools and in residency programs for OBGYN in certain parts of the country, you can guess where, there's very little emphasis on contraception, adequate education around contraception, and almost no education around abortion. So I trained in Texas as an OBGYN. I was not trained to perform an abortion. And so that's common as well. I would love to see a world in which we make sure that all physicians are taught about women's health in a much greater detail. And we're working on that here locally, but nationally it would be wonderful. So I don't know if you have any final thoughts. We have about 3 minutes left. But the last question sort of focuses on whether or not some of this is, or most of this is driven by religious extremists or lawmaker allies that see this only from one Christian religious perspective. I think we've talked about that in other panels. I don't know that that's entirely accurate. You'd mentioned a few minutes ago that a large proportion of our United States populace is uncomfortable with abortion for a variety of reasons as we move further and further along in gestation. So I don't think it's always a religious issue, although you may correct me, it does seem to be prominent in the most recent appointees to the United States Supreme Court, of course, but it's not always a religious thing. And any other final comments that you have?
Yeah, I mean, I think that the anti-abortion movement is like most social movements in that it's complicated. So there's some religious diversity in the movement. There are people who are, and I think it's also probably worth distinguishing the political anti-abortion movement from Americans who are uncomfortable with abortion, or even Americans who self-identify as pro-life, because the latter two groups are a lot more complicated than the political movement, because the political movement, of course, has hitched its star to the GOP to the extent that there's not really any daylight between the two at times. And that makes, that means that there's more homogeneity. Even there, I don't think there's homogeneity, but more homogeneity than you would see among other Americans who are uncomfortable with abortion. And I think, why people are uncomfortable with abortion is complicated. Some of it is religious, some of it just has to do with long-standing discomforts around gender and sexuality in US history. I think some of it has to do with racial politics, given who's having abortions and why. So it's very messy. But I think if there's one thought I'd want to close with, it's that I think there's a feeling generally of kind of inevitability and powerlessness that a lot of people have now, because it seems that we're just waiting for the Supreme Court to reverse this decision. We know they're going to. It doesn't feel like there's much to do about that. And as my primary role and as a scholar is as a historian of this stuff, and I can tell you that generally when things feel the most inevitable and fated is when things change the most. So there's a lot that people, particularly healthcare providers, can do to change what happens next, whether that's politically or in terms of care. And so I would say, if you study the history of this, you'd be probably feeling less hopeless. You would see that this is but just a point in a much bigger story versus, the end of a story. So I would encourage people, as they continue conversations about what they want to do now, to think about it in those terms.
Oh, I'm glad that you shared that. And I think it's absolutely true. Reading the documents before Roe that Yale puts together is really helpful to see that progression of where we were before, or even going as far back to Horatio Storer and seeing that we're playing out this sort of wave of this issue over and over and over again. Does help you to see that there's still ways to make change and to help people out. Thank you so much for taking the time today. I'm really very sincerely grateful, and I'll be sure to pass this along to all of my colleagues.
Yeah, thank you. And thank you everybody for coming.
Thanks everyone.